Mr. Mythbuster!
Today we're going to talk about 10 estate planning myths. Myth number 1, estate planning is only for the rich or the very wealthy. And if you've heard or seen any of my videos, then you know that is absolutely not true. Estate planning is for everyone. I always say the most important thing I think of estate planning is what happens to you if you become incapacitated. Yes, we do care about what happens to our assets, I hope you do, after we pass away. What is more important is how you want to be taken care of during your lifetime if you are to become incapacitated. All of those decisions are up to you, and an estate plan will give everybody guidance on exactly what you want to happen. Myth number 2, if I have a last will and testament, I avoid probate completely. And if you watched any of my videos, you know that is absolutely not true. A last will and testament just provides guidance to the probate court, which means your assets are still going to have to go through the probate court, but a last will and testament provides guidance to the court and to your heirs on what you want to happen to your assets. That's a very important distinction, because if you don't have a last will and testament, then most likely that same court is going to look at your state's laws of intestate succession on how to distribute your assets. So a last will and testament does not mean you avoid probate. What it means is how you want your assets distributed, and it gives the court and your heirs guidance on exactly what you want. Myth number 3, I must have a revocable trust in order to avoid probate. Now, if you've seen any of my videos, you know that I love a revocable living trust centered estate plan. I really and truly believe that is the best way to create an estate plan for incapacity planning and for what happens to your assets afterwards. But there are several occasions when people come into our office, and I really don't think that is good for them at all, because it's just not worth it for them to spend the thousands of dollars to get a revocable trust package and all the documents that go along with it when they really don't have a lot of assets. And so sometimes people will come in, they live month to month, they have an apartment, so they don't own any real estate, they may or may not have a car, and because they're living month to month, on any given month, there's not a lot of money in the bank account. In those cases, then you probably don't need a revocable living trust, but you need to talk to an estate planning attorney to see what your options are. You might be able to do a joint tenancy deed with right or survivorship. Now, there's some serious cons to that, but that's one thing you can do. On your bank accounts, you can list somebody as the pay on death beneficiary. In some states, going back to real estate, there's also what's called a transfer on death deed, where you can say when you pass away who that property goes to. And then on insurance policies and your IRAs, retirement accounts, you can designate a beneficiary on who that goes to. All of those examples that I just gave go outside of the probate. So it doesn't matter whether you have a trust or a last will, it doesn't matter what those documents actually say, because if you have set up all those beneficiaries correctly, then those entities, those financial institutions, are just going to pay out directly to whoever your beneficiaries are that you have listed. Now, there are some serious cons to all of this, like we've talked about in other videos. Do you want your kids to have your assets? Do you want your wife to have your assets? Or do you want your wife's new husband's kids to have your assets? So there are some really big drawbacks, and the best thing to do, I still think, is a revocable living trust package, but it's not for everybody. So check with an estate planning attorney before you make a major decision like that. Number 4, I should put my house in joint tenancy with right of survivorship with my child, and that way we'll avoid probate. Well, yes, it might work, but I can tell you from over 20 years of doing this that in most cases there is consequences to doing that. So just a couple. First, in the eyes of the IRS, that transfer from just your name to you and your child, maybe your daughter, as joint tenants with right of survivorship could be deemed as a sale and could trigger a capital gains event. So you need to talk to your lawyer before that, talk to your accountant before that, to make sure that you have determined what all the tax implications are. In addition, once you put that person on the property as a joint tenant, as an owner of the property, they're an owner. And that means if they're married, then their wife also has a marital interest in that property, or their husband has a marital interest in that property. If you were to die first, you wanted to go to your son or daughter, so it transfers to them. But if they die first, then you're back with that house. And what if you guys die simultaneously in a car accident? Then who gets it? It may not go to who you want it to go to. So it sounds good to put a property, real estate in joint tenancy with right or survivorship for one of your children, but very rarely do I see it actually work. The other problem I see is that mom always says, we're going to divide this house up 3 ways between my 3 kids, but they only put one person's name on the property as joint tenant. So when mom dies, that one child gets the property. It does not matter what a will says or a trust says. The deed to the property says that child number 1 is a joint tenant with right or survivorship. And when the mom dies, that property becomes that child's, child number 1 becomes their property 100%, and they do not need to share it with anybody else. A will or a trust decides ultimately who will receive my IRA, my life insurance policy, or even my house. And just like I talked in the previous myth, this is absolutely not true. If your IRA has a beneficiary designation, then that financial institution does not care. Let me repeat that. They do not care what your will says. They do not care what your trust says. All they care about is that you have listed a beneficiary, and that's who they're going to pay the money to. Same thing with an insurance policy. The insurance policy does not care what your last will and testament says or your trust says. All they care about is who you've listed as the beneficiary, and that's who they're going to pay out to. Now, I have seen some insurance policies pay out to the estate or pay out to the trust, but if they don't do that, if they list a specific person, let's say mom left her insurance policy to Enrique. Her last will and testament says money for my insurance policy is to be split equally between Enrique, Monica, and Jessica. Well, they think that they're each going to get a third, but in reality, the insurance company is only going to pay out to Enrique, and the other 2 kids are going to be left out in the cold. So do not think that just because you have listed somebody as a beneficiary, but you have listed 3 people as receiving that item in your last will and testament, that that's who's going to get it. You need to talk to an estate planning attorney before you make decisions like that. Even talk to the person at your human resources to make sure you have all these beneficiaries done correctly. All I need to do is fill out the beneficiary designations in order to avoid probate. We're talking about beneficiary designations like on your bank accounts or your insurance policies or your IRAs. Yes, that could happen. And like I've talked about in previous myths, have a very small estate, maybe you just have 1 child or 2 children, then that might work. But you always have to be cognizant. You always have to think about the fact that somebody may die earlier than the other person. Let's say that your child dies before you and you've listed them as a beneficiary. Now, in your mind, you wanted that money to go to your grandchildren, to their children. But if you just listed them as the beneficiary, then that money is still going to pay out to their estate. And that means if they are married, then the wife, that son-in-law or daughter-in-law who you didn't like, may end up with the money. So you need to be really careful with your beneficiary designations. And like I said, always, do you want your child, do you want your grandchildren to get your money, or do you want your son's, wife's, new husband's, kids to have your money, leaving your grandchildren out in the cold with nothing? So think about that. Talk to an estate planning attorney before you make any decisions like that. Number 7, a revocable trust will protect my assets if I end up in a nursing home. No, absolutely not. And along that same line, a revocable trust will not protect your assets from your creditors as well. For some reason, I think people get told that at seminars that come through town really quick and try to sell people certain financial documents or maybe even a estate plan. That is absolutely not true. If you need to protect your assets for nursing home purposes, then we're talking about a Medicaid protection trust. That's a completely different animal. If you're talking about protecting your assets from creditors, then you're probably thinking about an irrevocable trust where you lose control completely over your assets because a third party has to be the trustee. You can still be the beneficiary of that trust, but you don't have control over the assets anymore. So if you have a revocable trust is considered an inter vivos trust. It's just like you. It will not provide protection for nursing home purposes, and it will not provide protection for you for creditors. A trust avoids probate. Well, hopefully, if you have a revocable living trust centered estate plan, all of your assets are titled in the name of your your trust. This is called trust funding. So your real estate, the deed to your house, is no longer in Sally Smith. It is in the name of Sally Smith, trustee of the Sally Smith Revocable Living Trust. Same with your bank accounts. Anything that has a title gets transferred or funded into the trust. But if you have an asset out there that you forget to put in the name of the trust, then that asset, when you pass away, will need to go through the probate process. So if you're going to go through the time and the expense of getting a trust, make certain that everything is funded correctly in the name of your trust. If my last will and testament has language that it gives my assets to my child per stirpes, then automatically my grandchildren will receive if my child is dead. And that is not true. If you want your assets to go from your child, and then if your child predeceases you or dies before receiving their entire distribution, then you need to make sure you have specific language in there that it goes to their children. You need to be very careful when you make or have language like this in your last will and testament or even in your trust document, and specifically state how you want your assets distributed and in what order. Usually people say that I want everything to go to my child, and if my child predeceases me or dies before receiving their distribution, then it goes to their children. If their children are also predeceased or have died, then maybe it goes to my other children at back up a level, or if there aren't any other children, then maybe it goes to my remote contingent beneficiary. So it's very important to have that in writing and state specifically how you want your assets distributed if somebody were to predecease you or die before receiving their entire distribution. Number 10, a will or a trust are the only estate planning documents that I need. And you know that that answer is not true. If you've watched any of my videos, then you know that you need a revocable living trust. That's what I like, a revocable living trust centered estate plan. And that does not mean you just have a trust, and it does not mean you just have a last will and testament. It means along with those two documents, you also have your financial power of attorney, you also have your healthcare power of attorney. You have an advance directive, also called a living will. You also have a HIPAA authorization. You have language in there. You have a bill of sale transferring all of your assets, your clothes, your furniture, everything that's in your house to your trust. You have to have all of these documents together to create an umbrella of protection. Just because you have a trust or just because you have a will does not mean you have a complete estate plan. You need all of these documents to provide an umbrella of protection over you during your lifetime, during incapacity, and really even for your family during your incapacitation, and then protection for your family after you have passed away.
I know I've thrown a lot at you today, so that's why we've prepared our free guide on estate planning. I'll put a link to it in the description below and in the comment section below that so that you can download it and get started in the right direction. And to help you out even more, watch this video up here and this video up here. If you enjoyed this video, then guys, please smash that subscribe button and click on the like button. And also click on that little bell so you'll get notified every time we post a new video. Have a great day and an awesome week. And as always, thanks for watching.